support a moderate livelihood. Today's meeting is taking place in a hybrid format pursuant to the House Order of September 23rd, 2020. The proceedings will be made available via the House of Commons website. So you are aware, the webcast will always show the person speaking rather than the entirety of the committee. To ensure an orderly meeting, I would like to outline a few rules to follow. Members and witnesses may speak in the official language of their choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either Floor, English, or French. For members participating in person, proceed as you usually would when the whole committee is meeting in person in a committee room. Keep in mind the directives from the Board of Internal Economy regarding masking and health protocols. Before speaking, please wait until I recognize you by name. If you are on the video conference, please click on the microphone icon to unmute yourself. Those in the room, your microphone will be controlled as normal by the proceedings and verification officer. A reminder that all comments by members and witnesses should be addressed through the chair. When you're not speaking, your mic should be on mute. With regard to a speaking list, the committee clerk and I will do the best we can to maintain consolidated order of speaking for all members, whether they are participating virtually or in person. I would now like, of course, to welcome our witnesses back again today. We have Naomi Metallic, Chancellor's Chair in Aboriginal Law and Policy and Assistant Professor, Schulich School of Law, Dalhousie University. We also have Dr. Thierry Rodin, Associate Professor and Canada Research Chair in Sustainable Northern Development, Université Laval. And as well, Dr. William Craig Wicken, Professor, Department of History, York University. Since the witnesses appeared with us before on November 2nd and already made their opening statements, we will now go to questions from members right away. We'll now go to Mr.
Point
Williams.
of order, Mr. Chair. Point of order, just quickly.
Yeah. Yes, Mr. Bragdon.
Thank you, Mr. Chair. This will just be quick. Just wanted to follow up in regards to, we had the call this week and an email correspondence, just for point of clarification in regards to the subcommittee. Just a quick clarification for a meeting regarding the subcommittee. If it's possible for the clerk or find time at another point other than committee time for us as subcommittee members to be able to meet, to go over some of the agenda items and witness lists, et cetera, some of that to be ready for some of the upcoming meetings that will be happening. If that is possible to find additional time somewhere else, and if not, then I would suggest that we'll need to, maybe as a committee of the whole, set aside some business time for committee business at the next committee meeting. I should say a week from, not the next one, but probably a week from today on Monday to have some time to deal with committee business. But I'm just wondering if it's possible for the subcommittee to meet at a separate time at any other point prior to next week's meetings. Thanks, Mr. Chair.
Yeah. Thank you, Mr. Bragdon. I believe in communicating with the clerk, we've been advised that if it is our wish to meet as a subcommittee, we would have to do it during normal committee meeting time. So we will try and accommodate in some way, whether it's committee business or whatever, to discuss the issues that you're talking about, our upcoming schedule. And I know Madam Gill also asked for something to be discussed in committee business. So we will look at trying to carve out a portion of a meeting along the way to do exactly that if we can't get the additional time. Sure. Yes, is this on the same issue, Mr. Jans?
No, I'm having technical problems. So I just wanted to make sure my headset's not working. Can hear me though, okay?
I can hear you, but it's up to the sound crew if they can hear you properly in order to continue, Mr. Jans.
Okay, great. Okay, interpretation's fine. Good.
Okay. So now we'll go again to Mr. Williamson for 6 minutes or less, please.
Thank you, Mr. Chair, and I'm so glad our witnesses were able to return. I hope you can understand at the time we were interrupted, and I was the primary interrupter. We had some important business to try to get the Fisheries Minister before us, and so here we are, and I'm glad we're able to proceed, and I'm also glad to report that the Fisheries Minister will be joining us the day after tomorrow this week. So your testimony will, I think, help inform us for that meeting. So look, I have some general questions, and I suppose I'll ask you to respond to them each briefly en anglais ou en français. Je vais poser mes...
In French or English. I will put my questions in English, but please, you can answer in French if you want.
Because I only have a few short minutes. Could I ask you, in the context of this study where we are undertaking, what would you say are the main differences between individual and communal Indigenous rights? And I'm hoping each witness could perhaps respond for 35 or 45 seconds.
Je pourrais peut-être commencer.
Merci.
C'est une question extrêmement légale. En fait, moi, je m'y risquerais même pas trop parce qu'en fait, c'est une question que se posent beaucoup d'avocats.
Because that's a question that many lawyers are asking quite clearly. There's a recognition of collective rights. There are exceptions in the Charter, but there are many cases in Canada where, especially in some cases, rights were given to families or individuals. There's no clarity on this issue, but the general understanding in Canada for the time being, in the past 35 years, is that they are collective rights that are recognized. But of course, that is evolving. Very good. Thank you very much.
Would any other witnesses like to weigh in on this?
Sure, I guess since I'm the lawyer, it would make some sense too. I guess I would probably ask you for more details about your question because it's pretty generally formed, but in terms of Section 35, it has been held by the Supreme Court to protect collective rights. However, the Supreme Court has also recognized that there can be individual exercises of those collective rights. So in a decision called Ben and Moulton from 2014, the court did say that in certain circumstances, they didn't set them all out, they never do, but there can be individual exercises of rights in situations where people could solely rely on those collective rights to defend against charges, for example.
Okay, thank you. And could I ask you, with that in mind, is it how do First Nations resolve these different rights in terms of a communal right that exists to, in this case, harvest lobster, versus an individual's right to also want to participate in it? Is there a mechanism to oversee that, to police that, to ensure that agreements are maintained, and or even that conservation levels are respected?
Sure. So there are several decisions from the Supreme Court now that suggest that a communal right implies a right to manage the right. So sort of an implicit right to self-government. So in Chilcotin, the Supreme Court referenced that in relation to Aboriginal title. But even in Marshall II, the Supreme Court talked about how these were collective rights. And in fact, there's a case that I argued in New Brunswick from the Court of Appeal in 2018, where the court there specifically said that the nature of communal rights mandates that the community regulate or authorize appropriate exercise of these rights by its individual members through ensuring equitable access to resources. So there's a management right implicit in the communal.
And so is that would can it be argued then that what we were seeing, what was happening on the waters in Nova Scotia, because it was sanctioned through a First Nation process, that those that were advocating it were trying to meet the test of the court? So with that, I mean, instead of individuals on the water, Indigenous as individuals,
We lost you, Mr. Williamson. Lost your sound. Your video is frozen.
Mine is?
Okay, you're back.
Oh, did you hear me?
Nope.
Oh, okay. That's odd. I'll repeat myself. Pardon me. Very briefly then, and I've lost my train of thought here. So with that in mind, with what was just said regarding those cases, is it fair to say that because Indigenous fishers were operating through the barrel of a self-regulated fisheries, they were trying to meet the thresholds that the courts had established?
I can only say, looking from the outside, I'm not their legal counsel, but
Yeah.
it sounds from the fact that there were communal management plans that were set in place it seems, looking from the outside, that's what they were attempting to do, which would
Right.
be consistent with the law.
Okay. Now,
Thank you, Mr. Williamson. Your time has gone over, and I did allow a little bit of extra time for you losing your video. We'll now go to Mr. Batiste for 6 minutes or less. But before you start, I want to impress upon the committee members to try and identify who you want to ask the question. You tend to lose time if you don't actually direct it to a particular witness. So keep that in mind.
Okay, I would like to ask a question of Professor Bill Wicken, and I've heard arguments that the Mi'kmaq were never part of the lobster fishery. Based on your research and your analysis, is that an accurate statement, or did the Mi'kmaq participate historically in a lobster fishery? Did they trade, sell that lobster? Can you let us know what your thoughts are on that?
Yes, thank you for the question. I hope you can hear me. I presented evidence in the follow-up to Marshall, which was known as R versus Alex McDonald, and prepared a 246-page report on this. I directly addressed that issue. We have extensive documentation from the late 18th century on into the 19th century about the involvement of the Mi'kmaq in the lobster fishery. We actually have a photograph, not a photograph, a picture from 1795, which shows a woman putting a lobster into a lobster pot. But we also know that before the treaties were signed, which was in the 1760s, that the Mi'kmaq were involved in the lobster fishery. They used this, they were fishing people, they exercised that right communally, collectively, and lobster was one of the many species that they fished and sold to non-Indigenous people in Nova Scotia as and throughout the Maritimes.
Thank you, Mr. Wicken. Just a follow-up on there. Can you give me a sense of when you point to when were the Mi'kmaq displaced from this fishery? And can you give me a sense of how come?
Well, this is a long process. It occurs from the point of the American Revolution during the 1770s and the Loyalist immigration into Nova Scotia in the 1770s and 1780s. Most Mi'kmaq people actually lived below the Shubenacadie River in the area of Queens, Shelburne, Yarmouth, as well as in Kings County. It's a gradual process through which they're dispossessed from their coastal areas where they have historically lived. And I mean, these are coastal people and they're a fishing people. Reserves are created beginning in the 1840s, but most of them are inland and very, very small. And as in Bear River and Shubenacadie, which is on swampland, they're not very accessible to coastal areas. So this is a gradual process. In the 1871 census, we have 22 people living, Mi'kmaq people living on St. Mary's Bay. We also have many other people who are living in coastal areas who are Mi'kmaq and fishing up until the early part of the 20th century.
Okay, I thank you for that. And my next question is for Ms. Metallic, Professor Metallic, that is. And I've heard a bit of discussion and where people have alluded that the Mi'kmaq have an individual right and a collective right. Is there anything in place from Mi'kmaq law or Mi'kmaq knowledge that would set limitations on an individual right to practice a moderate livelihood?
Yeah, so there is this concept in Mi'kmaq called Nadugalimk, which is a broad concept that it generally, we're doing some research on, what it fully means. I think there's some more work that can be done on that, but it's generally regarded, and the Union of Mi'kmaq, Unama'ki Institute of Natural Resources has some good information on this as well. But that it's a concept about stewardship and resource use that is intended to provide for people but not take excessive amounts. I don't have the exact definition of it, but that could be a very helpful Mi'kmaq law concept that could help in the management of this communal right to manage.
Okay, just to follow up on that, in your initial speech, you had noted that there was a time where you acted for the Assembly of Nova Scotia Chiefs when there was no mandate under the fisheries. Can you give me a little bit of sense of when that was, where that litigation was? What was the background besides that, behind that litigation, and what ended up happening with it?
Okay, it's on public record, so I think it's fine for me to talk about, but it was a case in 2013, and this was after the Assembly had been at their tripartite table for quite some time, waiting for the Canadian negotiators to come to the table with a mandate to negotiate fisheries. And by that point, they had, gotten quite frustrated and wanted to see Canada come to the table with a mandate. And that was, a part of what was driving that litigation.
And what ended up? Did the litigation stop, or what was the overall what happened to? Is that litigation still ongoing?
It's in abeyance. So after a period of time, at first Canada tried to fight the case, but we managed to keep the case going. But by the point it was clear that they were not going to get the matter struck, negotiators then came to the table and said that they had an increased mandate to negotiate. But here we are 7 years later.
And what year was the increased mandate given to the negotiators?
That was in 2013. So we had put the case in abeyance. It was started in 2013, and we put it in abeyance in that year too.
Okay. All right. So just following up on the collective right, and I don't think you're going to be able to talk about that. Is that how do we as communities figure out how to balance collective right versus individual right in your best 30 seconds? How can we do that?
Well, we got to see it as through, I think Mi'kmaq law and a Mi'kmaq lens can help us see that. We were people who shared with each other. We weren't, we recognize we were a communal society. And so I think our own values can help inform that.
Okay, thank you.
Thank you for that. Thank you, Mr. Batiste. We'll now go to Madame Gill for 6 minutes or less, please.
Merci. Thank you, Mr. Chairman. I'd also like to thank all the witnesses who've come back today. When we left each other a few weeks ago, I talked with Mr. Rodon. We said to what extent co-management could, to some extent, reduce tensions according to circumstances, of course, and that this was a model for some communities in order to manage the resources appropriately. I'd like to hear Mr. Rodon about what would be needed in order to establish a co-management formula. We see the tensions that have taken place in Nova Scotia. Is there something missing right now in order to establish some kind of co-management formula? Thank you for the question. I'll try to start a little farther back. I had contacts with fishers in the North Shore because they had a tense situation that's not as bad as the one that we've seen with the Mi'kmaq, but there was subsistence and commercial fishing. They had to buy back permits and so forth, and there was subsistence fishing as well. There was a lot of friction at the outset. Even it was on the same magnitude, there were no criminal acts and so on. But by talking about this with the Innu fishery manager, they said their solution was to be at the heart of fishermen associations. The Innu and the North Shore are part of the North Shore Fisheries Association, all the fishers. So there was a proactive will that they be part of that association, to have a voice, and in order to progress. I think that's what's not happening in Nova Scotia, where quite clearly there's division and strong tension. Now, to get back on that, sometimes there's extreme tension. It's a means of forcing people around a table to find solutions. There has to be a role for the federal government, which can be important. Everybody is there to stay, as we said at the outset. Everyone's entitled to their share and entitled to have an appropriate standard of living. Let me remind you that the unemployment rate among the Mi'kmaq in the community we're talking about is 20%. That is double of the Nova Scotia unemployment rate. So that's an economic question. We have to find a way to manage the resource responsibly. But my working experience with the Innu is that they have every interest in managing the resource responsibly. The Aboriginal are not going to leave. The Mi'kmaq who are there for millennia are not going to use up the resource and then move away. Sometimes other fishers will. So I don't think these are arguments that are valid, that the Indigenous fishery will destroy a livelihood for everyone. It's no one's interest. However, some means has to be found to remove that distrust. There has to be a place where people could talk to one another and show that there's responsible management from all sides. Not just the Mi'kmaq has to demonstrate that. The commercial fishers have to do so too. Define what can be caught, what shouldn't be caught, etc. I don't think, in my humble opinion, that there's any other way. Thank you, Mr. Rodon. So if I reformulate what you're seeing, we have everything in place to meet, and I think meeting is exactly the right term. We have to discuss. There's a lack of will on one person who could be the Department of Fisheries and Oceans that facilitates people meeting. Yes, it should be its role. It has been its role in the past. I'm a bit surprised, in fact, on the lack of action of DFO in this conflict. Some have mentioned that. Fisheries and Oceans, after the Marshall decision, after long-standing practices, was much more proactive with the Innu, but now has chosen not to be very present in this file. So I think that quite clearly it's not the fishers or the Mi'kmaq who can solve this alone. The federal government has to make sure that there's some kind of arbitration. I don't know if that's the right term, but the federal government has a responsibility for the Indigenous people, a fiduciary responsibility, and protect the rights of the Mi'kmaq to have access to the resource. That's a right that is recognized by treaty, constitutionally, while allowing that there not be conflict and tension in the region. It's the absence of will, in my opinion, as many have said, on the part of Fisheries and Oceans to get involved in that region that has created this tension. Thank you, Mr. Rodon. Thank you, Ms. Gill. I've already talked 6 minutes. Wow. Thank you, Mr. Rodon.
Fun. We'll now go to Mr. Johns for 6 minutes or less, please.
Thank you, Mr. Chair, and thank you to the witnesses for coming back to this committee to testify. We greatly appreciate you being here. Maybe I'll start with Chancellor Metallic. Maybe, we've talked, it's come up several times at this committee that in the course of our study that we could be doing more harm than good, given that there's discussions with the Department of Fisheries and Oceans and the Sabaganagati. Can you maybe cite some recommendations that this committee could bring to Parliament that would actually support those discussions without undermining their legitimacy?
Okay, so I mean, I think some of Monsieur Rodon's suggestions around co-management, I think that's really key. I think it's the parties working together and talking together, and the the legal context here is complicated, right? It's not black and white, and that was the article that I had submitted to you, to the committee, that it's not black and white, that the Supreme Court has this very complex text that requires the government to meet its fiduciary duty and the honor of the crown, but that it's not a checklist of what you about list to each other. I think it's really recognizing that the Mi'kmaq people have an interest in here, not just to fish, but also around the management of this right as well, and as being treated as a nation and not simply just a stakeholder. I think that's really key. And I think the other part of this is you can't see this as a one-time thing, you know, that, oh, we'll solve this, we'll throw some money at it and it's going to go away. It's about a relationship between two nations. And it will grow and change, and it will continue to require nurturing that relationship and actually looking at things. So what is a moderate livelihood in 2020 is going to be different than what's a moderate livelihood in 2030, and the role you know, of the parties in that, and various other factors can influence that, but those would be some of the key things.
So when you talk about co-management, and I really appreciate that, when we look at monitoring and enforcement of treaty fisheries, does DFO have that mandate if the nations have actually asserted their governance by passing its own regulations within their treaty fisheries management plan? How does everyone move forward there in terms of with the department?
I think with getting out of the mentality of one government enforces and the other one, or, you know, or the other one's not really a government, doesn't have any say in it. So I think it's working together to address mutual issues of concern. And there are some examples of this. Monsieur Redon already gave some. I'm from the Listagouche Mi'kmaq First Nation, and we've had our own fisheries law since about the mid-90s, and we have our own rangers program. And so we have our own enforcement officers who go out in the water. This is not new, right? There are models out there to look at. So that's what I would say.
Okay, you know, we've heard DFO, you know, obviously wanting to work more towards an Aboriginal communal license that could be made available. But that's inconsistent with the nature of their Section 35 rights for the Sipekne'katik. What other viable options is available to the minister? We've heard it. They've talked about 4.1, which might be better suited to support the cooperation within the two parties. Can you maybe speak about some of the options around that and the common interests so that they can exercise their right to a moderate living?
It's hard in sort of the abstract to give lots of examples. I mean, I think, again, it goes back to talking through on probably species by species. So lobster might be different from shrimp, and various other species might be different, but looking at, well, what are the demands on the fisheries, right? It's actually honestly talking together about, you know, what are their conservation issues, is not what are the other demands on the fisheries from others, because, you know, the court did say that Canada can also consider the interest of other fishers, but at the same time has to show some priority to the treaty right. And so it's hard to give like a rule book, because it's not. It's a conversation, and actually like honestly talking to each other and listening and recognizing the Mi'kmaq interest and giving it priority, and also recognizing the Mi'kmaq management or governance interest in this too is, I think, really key, because that's what, you know, the model for the last 20 years with the Aboriginal communal fisheries licenses under the fisheries regulations. I mean, that was never set up to be a response to Marshall in the first place, but because it treated the Mi'kmaq exactly like any other stakeholder, that is a huge part of the problem.
How much time do I have, Mr. Chair? 1 minute. Okay, I'm going to go, Professor Wickham. You know, this obviously this study is taking place just after the Marshall decision came, you know, 20 years ago. And at the time, that committee found DFO was caught off guard. Do you think that right now DFO has been caught off guard in terms of preparing a situation that's unfolded with the Sipekne'katik?
I'm really not in a place to answer that type of question, Mr. Johns. I apologize, but I'm just an historian. I can give you an historical perspective on that, but I can't answer contemporary questions like that.
Historically, then, do you believe that there's systemic racism in the Department of Fisheries and Oceans?
You know, I think that's first of all, I have to define what you mean by racism. And I've already said in my opening statements that I think there are many good people within the Department of Fisheries and Oceans. I know within the Government of Canada, there are very good people, and some of them are listening on today. So whether or not there is or not, it seems to me, is something to address to the Mi'kmaq as well as to non-Indigenous fishers.
Mr. Rigon, did you want to comment?
Thank you, Mr. Johns. Your time has gone a little bit over. If I don't hear any objection, I'm going to make an executive decision to do a full 3-minute round for all 4 parties to have 3 minutes each before we finish with this group of witnesses. I'm not hearing any objection. Mr. Arnold, for 3 minutes or less, please. You're on mute.
Thank you, Mr. Chair, and thank you to the witnesses for coming back today. I'll start with Ms. Metallic. DFO determines fishing season dates that stipulate season openings and closing for species including lobster. Do these dates represent an infringement on Aboriginal treaty rights?
Yes, they can. It depends. And that's what the Supreme Court of Canada said in the Marshall decisions, is that with respect to Marshall, the dates that were set, he was fishing outside of closed fishing seasons, was found to be a violation. So absolutely. But again, it goes back to looking at species by species. What are the issues? What are the conservation concerns? So it's not a yes or no answer.
Thank you. In what has become known as Marshall II, in paragraph 6, the Supreme Court states that in a series of important decisions commencing with the R versus Sparrow 1991 SCR 1075, which arose in the context of the West Coast fishery, this court affirmed that Section 35 Aboriginal treaty rights are subject to regulation. In paragraph 61 of the Marshall decision, Justice Binney, for the majority rights, catch limits that could reasonably expected to produce a moderate livelihood for individual Micmac families at present day standards can be established by regulation and enforced without violating the treaty right. Do you agree that based on the Marshall case, DFO has the right to regulate the fishery for both Indigenous and non-Indigenous commercial fishers, including those seeking a moderate livelihood?
There is, but I'll point you to the article that I provided to the committee that regulate doesn't mean regulate in the way that the Crown can unilaterally do whatever it wants. My article sets out how the various Supreme Court of Canada decisions from Sparrow to Gladstone to Badger to Marshall set out a very detailed process about how that regulation with respect to Aboriginal and treaty rights is supposed to happen.
Okay, thank you. Should the fishery eventually result in legal pluralism here with more than one governing body, how should the Canadian government or DFO and First Nations resolve the differences of law and regulations and policy?
Through negotiating with each other, I think that would be the first thing. I don't think we would want to resort to the courts, and it works okay. It can be bumpy at sometimes, but federalism exists in Canada. That's how the government and the provincial governments work things out for the most part, usually trying to negotiate. Same idea.
Time, Mr. Chair.
10 seconds, but so I guess we'll move on. Mr. Morrissey, for 3 minutes or less, please.
Thank you, Chair. My apologies for technical issues. I want to go back to an answer that Ms. Metallic gave. And was I correct in when you said you were referring to the Marshall Court decision that the courts, the dates said he was in violation? Could you just clarify on that answer you gave?
I think so. So the court in Marshall 1 found that a seasonal Marshall was fishing out of season. The court found that to be unconstitutional. The restriction on fishing within season was unconstitutional in that particular case.
Okay.
That answer your question?
Yes. I just wasn't sure where you're going. So I want to, if you could make a comment on this question. Because I'm not sure anybody has referenced it so far, has the transfer, there is a perception that since Marshall, there's been a vacuum as it relates to First Nations community accessing fisheries. And we all know the record will state that there's been a significant transfer of fishing rights and access to the fishery to First Nations communities since Marshall. So my question would be, has the transfer of fishing licenses since Marshall 1999 never satisfied any definition of moderate livelihood? Ms. Metallic?
Sure. I, in fact, addressed this directly in the paper that I had given to the committee and was recently posted as an article on policy options. But one thing is that the commercial agreements that came out of Marshall, the negotiators actually told the Mi'kmaq this was not the implementation of a moderate livelihood right. So to see it as such is problematic given the representations that were made. Beyond that, yes, it gave access and that helped the communities financially. However, one of the issues with respect to that is that, over 20 years, populations grow within the community. The boats that were provided get old, the licenses become not sufficient to meet the needs. And so this idea of a relationship that continues can't just be a one-time thing. So that's a challenge, I think, with looking at
But going back,
access.
going back to your comment that it would be problematic. So therefore, if DFO was to remove the fishing license, the access to the fishery that occurred, would it not have any negative impact on the continued negotiations on moderate? Could DFO remove those and say, okay, they're not, the only part was moderate because there was no onus from the court decision to do that. The onus was on allowing a moderate livelihood. Would I be correct in assuming that those licenses could be removed from the equation?
Well, I feel sort of apples and oranges. We're talking about a moderate livelihood treaty right, and you're talking about commercial access, and the government presented it as just being commercial access at the time. Sure, maybe it could, but potentially do that. It's a separate question from the moderate livelihood right, but the government had to.
So you do acknowledge it's separate, and
sorry,
the
Mr.
government
Morrissey,
is not bound by it. Okay, thanks, Chair.
Your time is up. Now we'll go to Madame Gill for 3 minutes or less, please.
Yes, exactly. Sorry, Mr. Chairman. Thank you. I'd like to put another question to Mr. Rodon about co-management again. I thank him for giving us the example of the Innu on the North Shore. We see that the tension is not the same in our province. We can discuss things, and we hope it'll remain so forever. I don't like to engage in fiction, but you have solutions right now. If you were minister of the Department of Fisheries and Oceans, what would be the first action that you would take? I know you're not a minister and nor am I, but what would be the first thing you would do to solve this? Because we're talking about an emergency right now. In order to mitigate the impact right now, the department is not going to do the negotiations on questions of law. Well, you're putting a lot on my shoulders here. The only political scientist didn't really manage to answer that, so without trying to fill the shoes of a minister, I'd say that quite clearly we need action. The inaction of Fisheries and Oceans has exacerbated the problem. This has been noted by many. It's increased tensions, there's criminal activity. It becomes much more difficult to negotiate, quite clearly. But there is a chance. I think that they named a negotiator. There could be proposals on the table to make sure that there's a proper management of the resource and recognize the constitutional right of the Indigenous peoples to continue this fishery. I had begun by saying that the history of the Indigenous in Canada is dispossession of the resources. We see these tensions. It's a player that's been eliminated who had a central role. It's tragic. And that's why it's important for the government to be present and avoid these tensions. There are solutions. And if the government is absent right now, in a co-management formula, are the parties involved able to start up this process without the impulse of the government? Yes, they can begin. There have been some examples. There are some co-management instances that have been undertaken where there were major conflicts. Users have decided to do it, but the government does have that responsibility. At some point, it has to be around the table. That's obvious. But the communities could, the leaders of these communities could agree to say, well, we'll find a solution to make sure that the resource is properly managed, and we'll make proposals to DFO afterward, for instance. Thank you very much.
Thank you, Madam Gill. We'll now go to Mr. Johns, but before I do, I want to remind Mr. Johns to put the microphone a bit closer to your mouth. They're having trouble getting you for the translation. So for 3 minutes or less, Mr. Johns.
Okay, thanks a lot, Mr. Chair. So I agree with Mr. Wickham that there's some fantastic people working in the Department of Fisheries and Oceans, but we've seen, a repeated set of bias against Indigenous peoples that inform decision makers and the government. Ms. Metallic, can you speak about whether you see that there's systemic racism within the Department of Fisheries and Oceans and how that's playing out for Indigenous people when it comes to fisheries?
I mean, I am not doing a study on the ground. I think that the lack of implementation by Canada sort of writ large in terms of moderate livelihood rights is a problem, and how it, goes down to the enforcement arm of the state, I think, is another aspect of that problem. But it does seem sort of at the top, and also the people who are enforcing the law are not recognizing Section 35 rights. With respect to the moderate livelihood, yes, there was the access to the commercial fishery post-Marshall, but that hasn't actually really been informed by or looking at what's actually required under Supreme Court of Canada cases. And I don't know if it's active animus, anti-Indigenous animus, but it's certainly not knowing the law or following the law or respecting the heart of the law. And I think that that's a really big problem, and that needs to change.
Do you feel that if the United Nations Declaration of the Rights of Indigenous People, if the implementation of the declaration in Canada would help avoid or exacerbate fisheries issues in the future?
I think it would help, but why not implement Section 35? It's in our Constitution. I mean, these are cases. This is not, some people say, oh, well, UNDRIP is just so, it's an aspirational. These are Supreme Court of Canada decisions from our highest court. It's the law. So, we could start there, and I don't see UNDRIP. UNDRIP would help that, but first and foremost, Section 35.
So when you talk about implementing the court's decisions, we frequently see the government, they lose in court or they get tested in court, and the first thing they do is appeal. Do you not see that as systemic racism? They appeal at every opportunity.
There's been many instances where governments have appealed, and I guess in some respects that seems to be, viewed as par for the course. I will note that in, I think, 2017, the government, put forth these litigation guidelines or standards that is supposed to reduce that. Although, I have been a litigator, and and as somebody who's read many Supreme Court of Canada cases, have seen that often governments will put forward positions that you wonder, is this really facilitating reconciliation or decolonization?
Thank you, Mr. Johns. That closes up our first half of our committee discussions for today. I want to again thank the three witnesses for your patience and indulgence, for coming back and for helping to educate myself and the committee on this very important issue. So we'll say goodbye to our witnesses. We'll suspend for a moment just till we set up our next panel. Thank you. Name. When you are ready to speak, you can click on the microphone icon to activate your mic. A reminder that all comments should be addressed through the chair. Interpretation in this video conference will work very much like in a regular committee meeting. You have the choice at the bottom of your screen of either Floor, English, or French. When speaking, please speak slowly and clearly. When you are not speaking, your mic should be on mute. I would now like to welcome our witnesses. In the second panel, we have Chief George Ganesh from the Eel Ground First Nation, Chief Executive Officer, North Shore Mi'kmaq District Council. We also have Chief Darlene Bernard, Lennox Island First Nations. We will now go to opening remarks for 5 minutes or less. We'll go to Chief Ganesh to go first. You're on mute. There you go.
Okay. Thank you, Mr. Chair. Can you hear me?
Yes, but I will remind you, if you're using a line mic, keep it probably close to your mouth so everything can be heard loudly and clearly.
Okay, I'll keep it close. Good evening. Thank you, Mr. Chair. My name is Chief George Ganesh. I'm the chief of the Nottawahanek First Nation, Eel Ground, and I co-chair Mi'kmaq Wealth of Buddha Hunt, which is the organization of our Mi'kmaq First Nations in New Brunswick. I have been the chief of my community since 1996, and I'm speaking to you today from Mi'kmaq, the unceded, unsurrendered territory of the Mi'kmaq people. Mi'kmaq are signatories to peace and friendship treaties with the British Crown, to which Canada is now a beneficiary. Our ancestors negotiated treaties in which they were promised that we would be allowed to continue to hunt and fish as we had for thousands of years, and to trade in these goods. Signing these agreements was intended to bring peaceful relationship between our people and yours. Unfortunately, this has not been the case. DFO rules have expressly been designed to systemically exclude us from the fishery. We had hoped that the Marshall decision would usher in a new era of peace and prosperity for our communities. We hoped that we would be able to work together to implement our right to a moderate livelihood in a way that was respectful of our rights as a self-governing people and in accordance with Mi'kmaq laws. Again, this has not been the case. Instead of working to implement the treaties, the federal government chose a policy response to a court decision, known as the Marshall Response Initiative. Under the Marshall agreements, instead of implementing a treaty-based fishery, DFO offered funding to bands to purchase licenses, vessels, and gear from existing fishers so that we could participate in the existing commercial fishery under DFO's rules. This was designed to appease non-Indigenous fishers, not implement Mi'kmaq rights. While some Mi'kmaq communities refused to sign, many communities impoverished and long denied any access to fishery felt compelled to sign these one-sided agreements. There were significant inequities in the funding and in the distribution of access to various fisheries. My community was specifically excluded from access to the lucrative snow crab fishery and access that all of our neighboring Mi'kmaq communities in northern New Brunswick can enjoy. Some communities also received much higher levels of funding per capita than others. We were told that these were interim measures. The inequalities would be rectified and that our rights would be implemented through trilateral negotiation tables. A table was established in New Brunswick in 2007 and 8. For the next decade, we made little progress, and DFO refused to negotiate. This was supposed to change in 2017 when the federal government came to our table with a new fisheries mandate and a new negotiator. When our chief first met with the newly appointed federal negotiator, Jim Jones, in December of 2017, we made clear we did not want this negotiation process to be a repeat of the Marshall Response Initiative. We wanted DFO to negotiate with the Mi'kmaq as a collective and respect our need to implement our treaty rights in a way that was respectful of our rights to self-determination and our nation-to-nation relationship. Specifically, we wanted to work together to define and implement a moderate livelihood, to recognize the fact that a rights-based Mi'kmaq fishery must be self-governing, and to provide access to our communities who have long been denied their rights on a priority basis. Unfortunately, again, this has not been the case. DFO came to the table with a mandate that they unilaterally developed. The mandate is to provide funding to purchase more commercial access and not define and implement a true livelihood fishery. DFO has again sought to undermine and divide us as a collective and negotiate agreements with individual bands. Although they acknowledge that purchasing commercial access is inadequate to address a moderate livelihood, they refuse to explore other possible solutions. Everything the Mi'kmaq have put forward as a potential solution to the impasse has been rejected by DFO as being outside their mandate. We have tried to express these concerns to a series of ministers, but these have fallen on deaf ears. Despite repeated requests, we have been unable to get a meeting with Minister Bernadette Jordan. In the responses that we do receive, she merely reiterates the same inflexible position that has already been heard at the table. This needs to change. In collaboration with the Mi'kmaq, the Government of Canada needs to revisit and revise DFO's negotiation mandate. The mandate must recognize our right to self-determination, and it must recognize a rights-based fishery must be self-governing in accordance with Mi'kmaq laws. I thank you for listening and welcome any questions you may have later. Oladio, thank you.
Thank you, Chief Ganesh. We'll now go to Chief Bernard for 5 minutes or less, please.
Can you hear me? I have a lot of notes, so could I use up the rest of his time? I don't know if he used 5 minutes or not. Anyway, I'll read quite quickly, but I'll try to be very clear, okay? All right. Mr. Chairman, honorable committee members, ladies and gentlemen, thank you for inviting me to present today. My name is Darlene Bernard, and I am the chief of the Lennox Island First Nation and one of the leaders of the Mi'kmaq of Abequit here in Mi'kma'ki. We are the beneficiaries of the constitutionally entrenched Aboriginal and treaty rights in PEI. I am not the first PEI chief to present to this committee on this issue. My predecessor, Chief Charlie Stark, presented to this committee with a different composition and a different chair almost 21 years ago. It is disconcerting that there has been no resolution in the 2 decades that followed. A day shy of 21 years and 2 months ago, the Supreme Court of Canada released the Marshall decision. It was a landmark day for my people, the Mi'kmaq. It confirmed what we have maintained for generations, that the treaty signed by our ancestors guaranteed our right to hunt, fish, and gather to generate a moderate livelihood. Our fishing rights have been practiced for millennia, were codified with the Crown 260 years ago, were entrenched in 1982 and affirmed by Supreme Court in 1999. The Mi'kmaq right to fish in support of a moderate livelihood is constitutional, the supreme law of the land in terms of Canadian law. As was done immediately following Marshall, we have been engaging our community in discussions and the decision-making process with respect to the implementation of our treaty right to fish. We have always acknowledged that the exercise of the right would be regulated. We understand that when the Supreme Court affirmed our treaty right, it was confirmed that the government of Canada would regulate the right. However, the ability to regulate is not unfeathered. The High Court outlined the purposes for which regulation was appropriate. Specifically, the livelihood fishery can only be regulated for purposes such as conservation and/or compelling and substantial public objectives. Any Crown attempt to regulate must be justified and must be consistent with the parameters set down by the Supreme Court of Canada, specifically in R versus Sparrow and then later in R versus Badger, which was referenced in Marshall. The ruling is clear. If the Crown is attempting regulation, it must justify the restrictions on the exercise of the treaty right as follows. There must be a valid legislative objective, and it must be remembered that the objective of the department is setting out must be upheld. The honor of the Crown is at stake in dealing with Aboriginal peoples. The special trust relationship and the responsibility of the government vis-a-vis Aboriginals must be the first consideration in determining whether the legislation or action in question can be justified. There must be as little infringement on the right as possible in order to effect the desired result. Further, the Aboriginal group in question must be meaningfully consulted with respect to the regulation measures being implemented. While the Mi'kmaq treaty right has been established, there is a heavy onus on the Crown to justify any limitations of that right. The minister cannot use her arbitrary discretion to limit the treaty right through regulation. Recognition and affirmation require sensitivity to and respect for the rights of Aboriginal people on behalf of the government, courts, and indeed all Canadians. The Mi'kmaq people have lived in Abeguet for 12,000 years, and our priority for the resources has always been and always will be inherently based on conservation. We are not looking to exploit the fisheries. For centuries, we have existed in accordance with the principles of Dudugalam, taking what you need and leaving the rest for the next generation. We have respect and gratitude for our resources. Any overfishing of a particular species in this country that has raised alarms over conservation have only happened as a result of post-colonial, non-Indigenous commercial fishing. The Mi'kmaq have survived for thousands of years by embracing a sustainable approach to harvesting resources. It is hard to adequately convey the level of disrespect felt and offense taken when we read about those, including current members of Parliament, trying to thwart our constitutionally protected rights by making irresponsible assertions under the pretense of unfounded conservation arguments. The Mi'kmaq are the original stewards of our land and resources, and this respect for Mother Earth and what she gives us will live on into perpetuity. It should also be noted that in late September, according to Dalhousie University research, there are currently no conservation concerns with the livelihood fishery. I say to this committee, we need leadership and decision-making based on science and fact, not based on innuendo and fear-mongering. It must also be noted that if there were to be any issues regarding conservation, the privilege-based commercial fishery would be the first place that limitations would need to be explored, not the rights-based livelihood fishery. I am not here to
Thank you,
debate.
Chief Bernard. Thank you, Chief
I'm not
Bernard.
even half done.
Well, actually, you're gone a little bit over, actually. And I know you have an extra long statement here. Committee members will be provided with your statement and in both official languages, if it already hasn't been done. But hopefully some of the rest of the things you want to say will come out in the line of questioning. It is a 5-minute time limit, and unfortunately we have gone over. So now we'll go to our first questioner, which will be Mr. Calkins for 6 minutes or less, please.
Thank you, Chair. Thank you to the witnesses
Please.
that we're hearing from in this part of the committee meeting. I've got a question for both of you, Chief Ganesh and Chief Bernard. What is your definition? And if you were in the negotiation room, and I know this is I don't want you to divulge any secrets in what you're trying to do or what you're trying to accomplish, but please help me understand, what is your definition of a moderate livelihood? And I'll put it in context. We know that the fisheries have been set up for communal benefit, and yet previous witnesses, including Mrs. Metallic, who was just here, before you said that there's individual acts that can be allowed within that context of communal benefits. And I'm just wondering, is the moderate livelihood for an individual who's fishing, or is the moderate livelihood a communal redistribution of that wealth so that everybody in the band has a moderate livelihood from fishing?
I can go first, Mr. Chair. Because our negotiations have been infrequent and not directly related to the directive to the court decision, it has been a challenge to even begin to talk about what moderate livelihood means to our community, could mean to our community. So what I can share really quickly is some information that would give you a feeling of where our communities sit economically. 2016 census data, the median family after-tax income in New Brunswick is $52,000. In my first station in Nottawahanek, it's $25,000 per family after-tax income. The unemployment rate in my community is at least double of what it is in New Brunswick. And we have a very young and growing population that needs an opportunity, that wants to be able to practice their treaty rights, that has not been given that opportunity to this date. I can tell you, we are a community of 1,000. We have close to 260 families. We have 6 lobster licenses that were part of the initial Marshall interim allocation. That doesn't satisfy any definition of moderate livelihood from my perspective.
So what would your definition of a moderate livelihood be then, Chief?
It would be an opportunity for all our members that would like to work in the fishery to have that opportunity. Right now, we have dozens that are asking me on a daily basis, Chief, when do we get a chance? When do we get an opportunity to go out and fish? Because to this point, they haven't been given that opportunity. And we've been trying. We've been sitting down with at every possible opportunity to say, listen, how do we make access available? We've submitted a plan to fish snow crab, fished by our members, for our members, to support the community overall, and a management plan based on available quota. And the response was from DFO was to seize our traps and to threaten buyers.
So right now, anybody involved in the commercial side, and I understand that there's lots going on in this conversation, but I'm just trying to help me understand. Right now, my understanding is that a commercial fisherman with quota going out for lobster, it's an effort-based fishery, and they have an opportunity to earn a livelihood. There's no guarantee based on their effort that they will actually get have a profitable year. The same could be said for farmers. The same could be said for anybody else that's in business. Do you believe that in your definition of a moderate livelihood, should there be a guarantee of that livelihood when you pursue the fishery?
I guess if our community was to be supported in a diversified fishery that would include other species, other available quotas, that might be able to be achieved. Any one fisher, any one license can have a good year, can have a bad year. But with more access, it would mean more of our members would actually have the opportunity to work. I mean, that's the first part of it. Is that if you're out fishing, you're being paid, at minimum a wage to be able to do that, then that is improving that life. That's improving that livelihood. Is it a moderate livelihood? Because we haven't had a great chance to really look at what that means, it's at this point, we're at the very front end of that conversation. What I'd like, at a minimum, if you were to say, just off the cuff, wouldn't it be nice for all of my, families in my community to have at least the median income. And by
and
no means, don't hold that to me. Don't hold me to that. But a medium income would be double of what our families see now after tax. So, and I don't expect that you know, that's.
Thank you. So,
Thank you, Mr.
am I out of time,
Calkins.
Chair? Okay.
You're dead on to 6 minutes, sir.
Can
I apologize for that. Not right now, no. It'll have to come up in other questioning, or you can write an answer and submit it to committee. We'll now go to Mr. Morrissey for 6 minutes or less, please.
Thank you, Chair, and welcome, Chief Bernard. Good to see you appearing before the committee from Lennox Island. A couple of questions. Chief Bernard, you referenced no resolution in the 2 decades that followed some martial. Could you outline for the benefit of the committee what access to fishery Lennox Island First Nation has now versus 1999?
Sure. Well, as far as the livelihood, the right to the livelihood fishery, a moderate livelihood fishery, we have nothing. We don't have a livelihood fishery in our community. We have a communal commercial fishery in our community. And what that is that there are 10 vessels, I guess, that fish commercially for the community. And that money is used to help with projects. It's to help with deficits, like from federal government, because we're underfunded and everything. So right now, like with livelihood fishery, we don't have that. But what we got whenever Marshall came down was we signed Marshall agreements, which had no prejudicial language in it at all. This was all about us getting access so that we could start teaching our people how to fish again, since we were pushed out of the fishery for 260 years. So we needed that access to bring it into our community. Now, these were negotiated agreements at the time. They were negotiated like in good faith. And I think if the government's thinking about clawing back that's just going to put more pressure on the bands to do the livelihood fishery. I think there needs to be more commercial access to all the bands so that we can lessen the pressure that's being felt for livelihood fishery, in my opinion.
And I appreciate that. And so I believe you addressed it. So the proceeds from the fisheries that the Lennox Island First Nation community is involved in now is distributed to the community on a communal basis?
Oh, not all of it. There are people who are in our community who fish like any other commercial fisherman fishes with 300 traps, and they go out, they feed their families, look after their families.
But Chief, were those acquired by them, or were they part of the licenses that were transferred?
All we have are communal licenses. These licenses, all of our commercial licenses belong to the band. So the band allocates them out to the community. They have to follow our management plans and everything else. Yeah.
But within that fishery, there is fishers that participate that keep all the proceeds. Am I correct? It's not
yes, but they also pay their own bills. They bought their own boats, and they've really been entrepreneurial, and we like that in our community. We like entrepreneurs, right? But there are many people in our community who are poor, who can't get a big boat or anything like that, but would like to go out and fish for a moderate livelihood by fishing maybe 50 traps. I don't know. We're going to be engaging our community and all our members all over the winter time to come up with like what the needs are in the community. We will develop a management plan and an enforcement plan. We have already engaged with the PEI Fishermen's Association. We've talked to them. I asked them, what's your livelihood? I said to the young fishermen, I said, so you go out there, you work hard every day, you come home, and at the end of the week, you get paid. You make your car payment, you make your boat payment, you get your groceries, you pay your rent, and you make sure your kids have what they need, and then there's a little bit left over, right? They said, yes. I said, so would you consider yourself having a moderate livelihood? Yes. That's good enough for me. If they're making that livelihood, then we should be able to be making the same livelihood, in my opinion.
Thanks, Chief, and I appreciate it. Does First Nations have access to snow crab in Lennox?
Yes, we do.
You do? Okay. And any other fisheries? Tuna, herring, mackerel?
Tuna and herring.
And those came post-Marshall, am I correct? You indicated.
Yeah, all of that, all of those licenses would have been a result of Marshall agreements.
So if you,
I'm not prejudicial agreements.
Yes, and I'm not sure if you were listening to the comments from Professor Metallic, who presents herself as an expert witness on treaty, First Nation treaty law. But she indicated that the transfer of fishing rights to the commercial, which was done by DFO, which now there seems to be a difference of opinion that maybe this is a process that should have never been involved. It should have went directly to defining moderate and proceeding down that particular route. What would your comments be on that? Is it one or the other, or is it a combination?
No. I believe that that our fisheries, like in our communities across the Atlantic, are all going to be different. They're all very diverse. But I think, like on Lennox Island, we have our food, social, and ceremonial fishery, which we'll always have. We have our commercial communal fishery, and we're going to be starting our rights-based fishery in the spring next year. So these are all different fisheries, but we're going to manage all of these fisheries under one umbrella.
But the one from the treaty rights was the moderate one. There was no court never directed DFO that it had to transfer commercial license to First Nations community. The court decision. So the courts upheld the right to a moderate livelihood fishery, and DFO then attempted to fill this with the transfer of commercial fishing licenses, which is for me, it's confusing and appears a lot of discussion. So you agree with that?
It is confusing, but I don't agree with that, no.
Okay, I appreciate that. One final question, Chief, you made a reference to, and I'm running out of time. I think I'm out of time, Mr. Chair. But you made a reference, excuse me, Dalhousie University, there are currently no conservation concerns. I did not hear any witness from Dalhousie University provide evidence to this committee that there was no conservation concerns with a livelihood fishery as it relates to some warm water fisheries and those. There was other biologies that express concern that there would be harm to the fishery if the fishing was occupied at certain times.
Thank you, Mr. Morrissey. You're gone over time. And we'll now go to Madam Gill for 6 minutes or less, please.
Merci, Monsieur le Président. Thank you, Mr. Chairman. I thank the witnesses that are with us today, Chief Bernard, Chief Guinish. Ms. Bernard, I know that you weren't able to finish your opening statement, so if there was something essential that you wanted to tell us and that you have not had time to tell us earlier, what would it be?
Whoops. Est-ce que la traduction fonctionne?
Is the interpretation working? The interpreter is working.
No. Sorry, Ms. Bernard, I believe you will have to go to the bottom of your Zoom and click interpretation and select English.
Okay, interpretation. Oh, okay, it was off. Okay, sorry about that. I apologize.
Pas de faute.
No problem. Mr. Chairman, can I have my time and repeat the question? Okay, so I was thanking both of you, Chief Guinish and Chief Bernard, for your appearing. I know, Chief Bernard, that you weren't able to finish your speech earlier, so I like to hear the essential point of the speech that you made that you did not have time to transmit to us. So perhaps you could discuss that. I would give you some space to do that right now.
You want me just to continue where I was reading?
Ah, je sais pas, mais je voudrais...
I don't know. I have many questions, but if there were any specific points that are major that you wanted to communicate to us.
I didn't have time to kind of look through them. It was still like 3 pages. So I will just answer questions. Because unless I can read it all.
Alors à ce moment-là, j'aimerais...
Okay, if that's the case, I know that you began community discussions back home. I'd like to know what came out of those consultations.
Okay, well, we've just barely begun the whole idea of engaging our community and talking about the livelihood fishery. So we're just beginning that. So we're setting up a plan, and we plan on engaging every community member 16 and up and talking to them about the livelihood fishery and what their thoughts are on it and how they see it happening, because we have commercial fishermen who fish next to commercial fishermen, right? So there's all kinds of different opinions in my community right now. There's very strong opinions in my community, and there are other people who just want to know, like, well, how do I get involved, right? So we're going to take the next 3 months and really do that engagement and really do a really good job of that so that we can come back to the community, give them an idea of what was the discussions were all about and a plan to go forward.
Okay, you talked about plans for the community, but in the process that we have right now, what action should be taken so that we can manage to establish a regulatory framework that would allow you to exercise your fishing rights? What would be the ideal process, in your opinion? And the question goes to Chief Guinness as well, both of you.
Well, I think that the process, like, we really do have to engage our communities first. Like in Abaguet, like, we are committed, both bands. Like, there's only 2 bands on PEI. We're committed to looking at it together in unity to build that framework, right? So we have Olnaway, which is our rights-based initiative, and they are going to be helping us with this to be able to build that framework around us, like on Prince Edward Island. We're small, so we can do things a little bit differently here too. Like, you know, we can work together and really come up with a very strong plan moving forward. I don't know if I answered your question.
Yes, I saw this in a broader way. What would you like as far as implication by the Department of Fisheries and Oceans? What would be the ideal? But of course, there's a micro level and a macro level to all this. I don't know if Chief Guinness also wants to jump in.
Well, I would just want to say quickly, like, about DFO. I think DFO's role here is to work with us to help us to develop our enforcement capabilities and our science ability, and to be able to work with them to be able to make sure that our waters are being fished safely and following the regulations that we put forward. In other words, I don't expect them to be cutting my traps.
I would ask that we actually have discussions with fisheries about treaty access. That hasn't happened with our communities. The DFO needs to change their mandate. It does not address moderate livelihood. And that needs to happen in collaboration with us. So far, it's a Jones rights reconciliation agreement that is on the table that has no latitude for movement. It asks, as part of the signing process, that we agree to not assert our treaty right for another 10 years if we sign into those agreements. I mean, we have not treaty fished for 21 years. And to ask us not to do that for another 10 while dangling, you know, some additional monies in front of us is an insult. We have raised this issue with the minister, and from our perspective, we say, you know, lift that non-assertion clause in those agreements. It's been 20 years, and sit down to really begin to talk about treaty access and including our members. Our political organization, MTI, is engaging with our communities now to see who wants to fish. You know, what skills do you have? What skills do you need? And we know what our challenges are in terms of you know, poverty in our community. It's a reality. This is a right. We want to be able to support our members, to make a livelihood, to support their families, to feel good about, you know, practicing, you know, a traditional skill. I mean, when you look at the Miramichi, like 150 years since Confederation, our community was, you know, had salmon galore that filled our rivers. That salmon was fished commercially by everyone but the 3 First Nations on the river. Fished to the point of extinction. Our communities were never allowed to take a fish and sell it. And you know, that really is that's hard to swallow, because my grandfather had a commercial license. He could catch fish finally in the 1960s to feed his family, but he was not allowed to sell it. You know, it was years later before, you know, there were finally court cases that would have, you know, held up our right to be able to fish, to support our families. So it's, we come from a hard, oh, sorry.
Thank you, Chief Ganesh, and thank you, Madam Gill.
Merci.
We are at the end of our time, but if I don't hear any objections from the committee, we can go for another 25 minutes before we have to come to a dead stop. So I'm not hearing any objections. So we'll now go to Mr. Johns for 6 minutes or less, please.
Thank you, Mr. Chair. And I want to thank both witnesses for your important testimony. Thank you, Chief Bernard and Chief Ganesh. Chief Ganesh, it's good to see you again. I met you with Fisheries and Oceans Committee when we landed in your community. Thank you so much for hosting us a few years back. You've been really vocal the last few months about the systemic racism that's been directed at the Mi'kmaq, and especially when it comes to the Savagin-Agati. And you know, you've also been speaking out about the justice system and the systemic racism that's there. You know, in terms of Chantal Moore, who's from my riding of Courtenay, Alberni, and the Newtownland people would like to also extend our gratitude to you for speaking out and about the injustices that not just to her but to Indigenous people. On the theme of systemic racism, we've heard at this committee that many Indigenous people have to just break the law for the right law to be put in place. And I'd imagine that this leads to greater instances of criminalizing Indigenous people who are just simply practicing their inherent rights. Can you talk about the systemic racism and how you see these, repeated set of biases that the government's bringing to the table and what needs to change? Sorry, I'll start with Chief Ganesh and then I'll go to you, Chief Bernard.
Okay,
That'd be great.
Okay,
Yeah.
I'll keep it short. Absolutely. It is a reality. It's it's our First Nation has been on the river here, Medabanagia, Nadawahanek, Eskanobadich for over 5,000 years. You know, we've always shared, and it's really bothersome that that we aren't extended that same courtesy. It seems that we have to continue to fight the battle, for equity, for access, for to be able to look after our and it's we've been talking with the Premier of New Brunswick about the need for I know this is off topic, but the need for an inquiry into the justice system here. Nova Scotia had the Donald Marshall inquiry, and our reality is that many of our people, because of their poverty, are making bad choices in regards to to how they survive, and they are prosecuted for that, and they cannot afford legal. So there's there's a number of things that we're putting forward with the province of New Brunswick to address that racism in the justice system, that systemic racism, that exclusion, marginalization. A number of our people are they will reach out, they will try to to work outside, and many times they will come back with stories of geez, I just wanted to work, and I got told, go back to the reserve. What are you doing here? What are you doing trying to take a job away from one of my family members? I mean, that's a real struggle. That is a constant reality for many of our people, and that hurts. I feel really bad for for our young people that that aren't willing to take the chance and challenge this really bad behavior. I'll leave it at that. I'll let Chief Bernard.
Chief Bernard, can you also expand on what you've seen in terms of the last 20 years, the 10 years under the Harper government, and now this the 5 years under the Liberal government, and the promises for change? Can you also elaborate, what the history of that over the last 20 years?
Well, I don't know. What I'll say is this: is that to me, all you have to do is look in the last 3 months and see what happened in Nova Scotia to see that there is systematic racism in our systems, right? You can't deny that. And I think people who don't want to come out and say, oh, there's systematic racism, you're denying it to yourself. It's there. We need to deal with it, right? But I want to just read this excerpt here that I think kind of brings us back to what I want to say. So in order to achieve the equitable and mutually satisfactory resolution we are seeking, the government of Canada must commit the political will, including the necessary resources, to the initiatives we are developing. It is imperative that the government of Canada understands that it does not have the answers. It cannot meet the challenges presented by the Marshall decision unilaterally. In order to avoid further unrest or further litigation, the government of Canada must accept that the process has to be truly cooperative. Through Crown Indigenous Relations and Northern Affairs, Canada must work with us as a good faith partner on a nation-to-nation basis to uphold the Constitution. So implement Section 35. And I think that just speaks to what needs to happen.
Okay, so here where I live in Newfoundland territory, we've seen the government knowingly go to the table empty-handed, spending $19 million just on government lawyers fighting the Newfoundland on their right to catch and sell fish. Do you actually believe that the government is sending their negotiators to the table with a mandate to, work with the Mi'kmaq on their moderate livelihood and their treaty right? Mr. Chief Guinness, could you also comment? Thank you, Chief Bernard. Yeah.
No.
I would say no. I mean,
no.
When you have a negotiator that comes to your chiefs that says, here's the package, here's the deal, take it or leave it. I don't see how that is negotiation. I don't see how that begins to address moderate livelihood. We've, many of our communities, because of the dire, poverty, had signed into these initial agreements 21 years ago in hope of building, helping build our economies. And 21 years later, why is it taking that long? Why is it taking that long? And I've shared, a stack of documents as well with the participants here. They weren't available today, but it speaks to our efforts over the last 10 years to try to get ministers to the table to talk about this. This isn't in the last 3 months. This has been going on constantly. And, it's.
The negotiation should be done by CERNA.
Thank you. We've gone over time. We'll now go to Mr. Bragdon for 5 minutes or less, please.
Thank you, Chief Bernard and Chief Guinness, for taking your time and being with us this evening. We appreciate you being here and joining us. And a couple of questions here, and I want to open it up just as it relates to, we've heard this in witness after witness after witness, and it has come up quite repeatedly, and it's been mentioned already in what you've provided to us this evening, that there is a growing frustration as it relates to the absence of direct communication, as it were, with the minister and with the department, as it relates to the Indigenous fishery, as well as with the fisheries in all of Atlantic Canada as it relates to that. And there's frustration that's growing, obviously, amongst the Indigenous communities, but also amongst the commercial fishery, that feel like there hasn't been proper consultation or proper communication or bringing people to a table of dialogue. I would like to get your thoughts as it relates to this. And do you feel like there has been adequate communication done with you as an Indigenous community, as well as with other stakeholders and interested parties, such as the commercial fishery in this area? So if I can have brief comments from both of you, that would be great. I'll start with you, Chief Bernard.
Okay, yeah. So I've had conversations, like with the PEI Fishermen Association in PEI. We've had our talks. I've talked to DFO on Prince Edward Island, and I've pretty much was, saying that we really need to sit down and have a discussion around this, because I think that they need to know what their role is, and I don't think that it's clear what their role is, because look what happened in Nova Scotia. I mean, cutting traps of the livelihood fishery, that was not their role. That was wrong. They shouldn't have been doing that. And I think, like with RCMP, like, we have to be careful. They have to know what their role is in all of this and helping to protect the Mi'kmaq, because this is about protecting the Mi'kmaq when we are asserting our right to a moderate livelihood. So I've talked to them. I think that really what has to happen, though, and I think that DFO has to be taken out of the negotiations. They shouldn't be negotiating our rights when they're trying to be enforcing fisheries. This needs to be on the CERNA needs to the table, Carolyn Bennett. She needs to be the one who's setting the parameters and appointing negotiators to come and talk to us. We want to talk to the negotiator, you know, and this whole thing about the RRAs, that rights and reconciliation agreements, those are nothing but a slap in the face to First Nations. And at the end of the day, if they have an envelope of money that they have and they're holding it up here to try to get us to sign these agreements that are detrimental to our rights, then that can't happen. We can't be signing those things, and that money should be just given to the First Nations so that we can continue to develop our commercial fisheries and our livelihood fishery.
Thank you, Chief Bernard. Chief Guinness?
Excuse me. Okay. Yeah, I would agree with Chief Bernard that, you know, these discussions, I think DFO has clearly shown that they're not capable of negotiating. And they're in a conflict anyway, where, you know, they're supposed to be enforcing, they're supposed to be regulating. And, you know, I agree with Chief Bernard that we need to meet with Canada is what needs to happen here. We need to meet with the Minister of Indigenous Affairs. And perhaps, you know, that's where this needs to begin. And there's a spot there for the Minister of Fisheries, but no more, you know, no more
Well,
trying
obviously
to treaty.
struggling.
Yeah, absolutely. But no more. I mean, it's for us to continue to meet with, you know, district or regional DFO. We haven't gotten anywhere in 21 years. Why would we want to continue that and you know, continue to raise the level of frustration and disappointment that, you know, clearly exists, you know, all across Atlantic right now.
Well, thank you to both of you. And it seems like it's been expressly pointed that you pointed out throughout this committee that there just has not been adequate dialogue, direct dialogue between all of the parties, in particular with Indigenous, as well as with the minister, as well as with the communities that are going to be directly affected by all of these decisions being undertaken and the talks are undertaken. Post-Marshall, can you describe the relationship that seems like, and you've referenced it somewhat in testimony so far this evening, and I believe you referenced it, Chief Bernard, that you've had ongoing talks with the PEI commercial fishery, and I'm sure Chief Guinness can speak to some of the fisheries in New Brunswick, that between you as communities and the fisheries, there has been some dialogue and conversation going on. How would you describe that post-Marshall? And it seems like that recently, perhaps maybe because of what's been happening in Nova Scotia and building beneath the surface, there's been a breakdown somewhat. Can you just speak to that, both of you? Thank you.
To Bragdon, I'm sorry, you're completely gone over time, actually, and I got to be strict on the time because I want to get into full rounds of questioning and be fair to everybody. We'll now go to Mr. Finnegan for 5 minutes or less, please.
Thank you very much, Mr. Chair, and thank you to Chief Bernard and Chief Guinness to take the time to be with us here today. And I'll start with Chief Guinness, and I'm sure it probably applies with also Chief Bernard. As you're certainly aware, Chief Guinness, you know, you've been involved with the negotiations and the so-called, in our region, it's the Jim Jones process that's been happening. And I'm not saying that should replace the treaty rights. We all know that. But and several communities have signed on to it, but many more have not. And in your opinion, what are the sticking points? I know this is just kind of I wouldn't call it a band-aid, but a kind of it's been 20 years since your community, Chief Guinness, has been trying to access a crab quota, for instance. So is there a way that we can at least get that and then move on to the rights? And I could ask both of you.
As far as, you know, communities signing into the Jones agreements, we don't know what they signed. So, you know, it's kind of hard to comment on what that was. But I know what was placed before, you know, our North Shore Mi'kmaq chiefs, our 7 chiefs, the poorest, you know, 7 of the 10 poorest postal codes in Canada are Northern New Brunswick. And we still would not sign those agreements. They're an insult after 21 years that they would try to lock our rights up again for another 10.
Right.
It's you know, it's really frustrating, Pat, and I think, you know, we've had this discussion a number of times, and you understand that you know, there's I guess when you look at the you know, the Jones agreements purport themselves to be per capita and fair. And, so I don't know, that might have influenced those communities. Maybe they had been treated more equitably, in the initial allocations, but our communities weren't. When I look at the 35 Mi'kmaq communities, and I look at the per capita that was given to our First Nation, we're like number 4 on the list. So I don't know how those decisions were made, but there was a great amount of unfairness in those initial allocations. And like I said earlier, you cannot build an economy for 250 homes for over 1,000 people with 6 lobster licenses.
Yeah, and I feel the frustration, Chief, and I know I've had several ministers up in our riding, including Minister LeBlanc and Minister Wilkinson, and we've gone over that. And for a while, I thought that at least we'd get to a quota, a crab quota. And
well, we have a license. We actually have a crab license. We have no quota, so figure that one out.
How does that happen?
Yeah, we got a one-time 100 ton allocation, one time. Yeah.
And you were able to fill that quota and use
it helped the community. It helped the community immensely. Like it generated $400,000. We're north. We're north in New Brunswick as well. So we have communities in New Brunswick have these HST revenue sharing agreements. And the communities that do well are the communities that are on the main highways, the Trans-Canadas. You get to Metabonagia, you get to Ile-Ground, and we're off the main drag. It's difficult to generate economic opportunity.
And what's going on? Sorry to cut you off. What do you see going on in Nova Scotia right now, Chief Guinish and Chief Bernard?
Oh, I mean, absolutely.
But I mean that I'm sure you're all following that. But and if you recall, last year you had some traps set out, which was seized by DFO. And how do you see that? And you see a inconsistent. I can't, the word.
Inconsistency.
Yeah, right.
Absolutely.
With DFO, how they treat.
We're still waiting for a response to a snow crab treaty management plan that was submitted to DFO in March of 2019. I shared emails with the package I sent around. Please respond. What is, we know that there's a surplus. Why can you not, allow Ile-Ground, the only Mi'kmaq First Nation in the Gulf region, not to have some access to crab to help build our economy? You can't get a straight answer. It's maddening.
Chief Bernard, did you want to comment? I know I don't have much time left, but
well, one of the things that I'm getting very frustrated with is that we've sent letters. We've sent a letter to the Minister of Fisheries and Oceans months ago in August, saying, we want you to get back here and talk to us because there's a lot of unrest going on, and we never even got a response to that. So, we're not getting responses when we're actually asking to come and talk to us. So I think that has to be changed. And I think that there's got to be a lot of treaty education that's got to happen in the Atlantic region. And I think that the government has to support that. And the government itself has to stop, the minister has to stop calling this an illegal fishery, because it's not an illegal fishery. And the work needs to be done by this committee or somebody to change the legislation so that it includes the livelihood fishery within the wording of that. And that's the work that you guys have to do.
Yeah, and I know I've heard
Mr. Finnegan. Thank you, Mr. Finnegan. We'll now go to Madam Gill for 2.5 minutes or less, please.
My mouse isn't cooperating. Thank you, Mr. Chairman. I would like to continue where Ms. Bernard was at. I like when people try to put themselves in the shoes of a minister. What should Minister Jordan be doing right now? What's the first action that the government should take? A lot hasn't been done in the past 21 or more years, but what should be done right now? What would you like to see happen? That's for Chief Guinish as well.
Okay, I would like to see that the mandate for the negotiation be taken from the Minister of Fisheries Oceans and given to Carolyn Bennett under CERNA, because she has the portfolio to work on rights, and this is a rights-based issue. It's not about commercial access in what her thing is, and she doesn't understand. I've heard her speak. She does not understand, and for her to call the fishery and illegal fishery as a minister of the department, and she should understand that stuff. So clearly there needs to be some education within the ranks of the government. That's what I would say. That's the first thing that has to happen, is that the mandate needs to be changed to a different department. Chief Ganesh?
Yeah, it's, I mean, it's unfortunate, the behavior in Nova Scotia when you have a First Nation that is exercising their legitimate right to a treaty fishery to be treated that way. It's heartening to know that not everyone feels that way. You know, according to the latest CTV Nanos poll, 74% of Canadians feel that, you know, Mi'kmaq treaty rights should be respected and honored. So, you know, it's you know, I guess that's how we have to move forward. We have to educate, we have to share, and we need that opportunity to sit down with the minister. Do we need to educate her? We'll do that. You know, it's we've been trying to do that, you know, relentlessly, but butting up against, you know, like I say, we did the same thing. We tried again this year to access snow crab. DFO is, you know, has a science quota of crab, 3,500 tons, that they use to generate money for their science programs. Why the hell can you not? And that was originally, and there was another set aside originally too for MFU when their lobster fishers were having a hard time. There was a quota that was used to help those fishers when lobsters were on tough times. Listen, First Nations have been on tough times for a couple hundred years. How about spreading some of that access around?
So release the RRA envelope.
Thank you, Madam Gill. We'll now go to Mr. Johns for 2.5 minutes or less.
Yeah, Chief Bernard, can you talk about what DFO could do to help support your communities in their need to develop their own moderate livelihood fisheries?
Okay, I think that they should release the RRA envelopes to the First Nations so that that money can be used for us to be able to do our engagements. We need to be supported in our engagements. We need the ministers, whichever one's going to be responsible, to come here to our communities and to talk to us. We need that. We need treaty education. We need that support. We need to have like DFO can support us in a lot of ways, helping us to develop our Guardian program so that we can develop really strong enforcement processes and capacity, which we are trying to do, but there's no support for that from the department. There should be support for that. So
great. That's really appreciate your response, Chief Bernard. And Chief Ganesh, can you speak about, you talked about education of your rights and making the space for you to determine what a moderate livelihood is for your communities. Can you speak a bit more about that and how important it is that Minister Bennett and Indigenous and Crown Relations is at the table?
It's, I mean, it's absolutely essential. I mean, we look at, you know, the TRC calls to action and you know, that in itself isn't happening fast enough here in New Brunswick. You know, we've got a provincial government that's kind of half-heartedly, you know, approaching that, and that needs to be embraced. I mean, we're in a situation where I guess we have to look at changing the minister's control of allocation of, you know, of quotas. You know, it's you got one person that has more authority in that one position than most any other minister. I mean, it's her word is it. There is no other. It's I mean, it's about time we put, you know, we gave priority, you know, to ourselves in sitting with DFO in being able to really move the ball forward on treaty rights. And it's long overdue. It's I lost my train of thought.
Yeah, I think treaty education
anyway.
is so important.
Yeah. Thanks, Mr. Johns.
Thank you.
Thank you. We'll now go to Mr. Williamson for 5 minutes, please, or less.
Thank you, Mr. Chair. And I want to thank the witnesses from Atlantic Canada who have come in today. This has been very, very informative. I think you've done a very good job explaining just the hardships that your communities have faced over many, many generations. And you've been asked we've heard from your perspective on possible solutions. You were also asked to provide input on what you would do if you had the ministerial authority. Could I ask you though, how, and this perhaps is the other side of the table, I'm curious to kind of get your perspective on how you see the development of or implementing the Marshall decisions, working with what I call the traditional fisheries, the commercial fisheries, the owner operator, those individuals. Do you have concerns about conservation, or do you think that's a non-issue? And this is really just a question of granting the space, or does one displace the other? How do you see the various communities coexisting in your regions or in your provinces? And if you, I'm more than happy to turn over the remainder of my time, provided you share it equitably, if you don't mind. So I'd like to hear from both of you. Yes, Mr. Guinish.
I would begin
Chief Guinish, pardon me.
I would begin by, following the rule of law that's how I begin. Is you have conservation, then you have First Nation access, then you have other user groups. That has not been the case. That has been ignored. It's like I said earlier. It's fortunes have been made, from resources that our ancestors shared, freely shared, and we've been denied. That's how I start the conversation. How do we get our communities, our First Nation communities, somewhat equitable with what every other, if the unemployment that exists in our communities were anywhere else, there'd be movement.
But is it really fair to say fortunes have been made? I mean, I see livelihoods that are made and a good livelihood, but not a fortune in the fishing communities that I know. Yes, no, please. I'm curious to hear your thoughts on this.
What I was referring to, I guess indirectly, was you have the huge companies. You have a Clearwater, which is really remarkable that now the Nova Scotia Mi'kmaq have a stake in that, and their communities can benefit from that, and that's remarkable. And that's what we'd like to see. We'd like to have other opportunities. We'd like to be have a Mi'kmaq brand, to be a part of a processing and other opportunities.
Yeah. Okay.
But it's that is yet to happen.
Yeah, no, fair enough. I mean, I'd point out as well, for many of the traditional fishers, these large corporate fisheries, as I call them, are the bane of their existence as well. They view them as a threat to their livelihoods and their communities as well. But I also want to give Chief Bernard some time just to respond to some of my questions. But thank you, Chief Guinish.
Yes, thank you.
Thank you. Okay, so you were asking about our relationship with the traditional fisheries on PEI.
Yeah, how do you see it coexisting going forward? If there's a complete entrance of Indigenous fishers as well, in terms of conservation and livelihoods.
Yeah, well, we're already in the fishery. We are fishing side by side to some degree with the traditional fishers, the commercial privilege-based fisheries, and we've had a really good discussion with them. The younger fishermen, especially, they asked a lot of really good questions. And what I learned from that discussion was that they really don't know about the treaty. The treaty right at all. So they were asking some really basic questions, which were really good questions. And they were saying, well, how come you guys weren't involved in the fishery? Why didn't you go buy a license when they were $25 a piece, So we had a really good discussion about, how we were pushed out of that, and that our people were completely, disassociated with everything that was going on at the time, when it came to our natural resources. And so the questions were really good. I see on PEI, because we're small, I think that because by doing all kinds of treaty education and getting out there and talking with people and helping everyone to understand that we are the Mi'kmaq, right? We're not here to exploit the resources. We've never exploited resources. So we want them to understand that we just want to have our people be able to have the same things that they have, fishermen being able to.
But let me ask you that. I mean,
thank you, Mr. Williamson. Your time has gone
okay,
over.
Thank you.
I have to try and get Mr. Batiste in for a few minutes. Mr. Batiste, for 5 minutes or less, please.
Thank you, Chiefs. You guys have done great. Very happy to have you. When we've discussed things with Nova Scotia Chiefs, they've told us that very much so that the Mi'kmaq aren't willing to sell their rights. Would you say that in New Brunswick and PEI, the Mi'kmaq would be very disappointed and angry at you as chiefs if the chiefs entertained any kind of discussion around selling rights? Do you think that's accurate?
We wouldn't be chiefs. We won't be chiefs very long if we start talking about selling out our rights. I'll tell you that much.
Yeah.
Chief Ganesh, would you
that's-
agree?
I mean, we have resisted the Jones overtures
Yeah.
that would require, non-assertion of our treaty rights. That's a no-go zone.
And our
absolutely
people
not.
would expect us to bring it to like a community discussion and a vote if we were to sign some kind of a rights prejudice agreement.
Okay, so there have been those out there that have called for, instead of a band by band approach, an approach that is based on Mi'kmaq nationhood by Mi'kmaqi or by traditional Mi'kmaq districts. Do you think, as chiefs from different provinces, there would be a way for Mi'kmaq chiefs to actually sit down and have a discussion that brings a nation model approach to the governance of fisheries? I'd like to hear from both of you. 1 minute.
Like a Mi'kmaq Fisheries Authority. Well, the senators have approached the First Nations on PEI to talk about that idea. And I know, like, I've approached the chiefs at an all chiefs meeting and asked, like, let's have a nationhood gathering. Let's have a Mi'kmaq nationhood gathering. Didn't get much uptake on it right now. I think right now everybody's kind of just trying to find our own way here. We're trying to get our engagement done and get our plans kind of started to go. So that's, I think, where we're at right now.
We had, okay, I'm good. Okay, we had actually met with Nova Scotia First Nations and NPEI, Newfoundland. The invite was sent out to all, and we had met in Membertou probably about a year and a half ago. And I guess the plan was to continue doing that. Yeah, the plan was to continue to do that and begin a dialogue on a number of issues and to talk about fishery would, that would be, I think, a perfect opportunity to do that. When the Jones agreements first came out, they were touted as nation-to-nation agreements. We had high hopes that was what would actually happen, and it didn't take too long for Jones and company to start working to divide and conquer.
Yeah. We always have the big nation to nationhood discussions, and then we all splinter off at the end of the day. I think it would be great if we could have the overarching Mi'kmaq kind of fisheries authority, and then everybody, like the provinces, work together. But I don't think we're going to get there really quickly. So for this winter, I think PEI, like, we're small, so we can get a lot of things done. We can come together in unity on a bunch of things, and we're small. We want to talk to all of PEI, all islanders. We want all islanders to understand our treaty rights, and we want them to be a part of it, because when we're doing really good, PEI does really good. That's just a known fact. We've done studies.
Absolutely, it's the same here. It's the same here. If our nations in New Brunswick, if they prosper, everyone else feels that. Miramichi especially.
Ripple effect.
You've got three First Nations on the river here that Miramichi would feel it if we all decided to take our resources to Moncton or to River Bar or Dalhousie. So, and we understand, absolutely, to be truthful, we understand how the smaller fishermen who are struggling, to survive feel. We would think that they would understand our situation better than most. Is that look at our poverty rates, look at our unemployment, and it's 21 years, but it was a really uneasy relationship at first. Like the few licenses that we have are in Point Sapan, which is like it's an hour from here. So there was it took a while to but the guys work together now, and it's not an easy life, and not an easy life fishing the winter lobster season in New Brunswick. The guys, good thing about it is that it provides employment for we got 6 licenses now. There's at least 2 or 3 First Nations from Millground on every vessel, so that is providing some employment. If we can double that or triple that, we're even better, in a better position.
Yeah. And I just want to say too, in our fishery, like our lobster commercial fishery, our communal commercial fishery, it's all First Nations people from our community who are involved in that. The management, the fishermen, right down to the deckhands.
One thing I want to
Thank-
mention before you cut us off, though, is, we've been talking about food diversification as well as commercial diversification, and we've been having a hell of a struggle to try to get any lobster food for our community. I've got a letter I included in the pack there from 3 years ago. It says, well, it doesn't look like we're going to be able to do it again this year. Looks like you're going to have to take it off your commercial communal. So and we've had to do that. Why? We're talking about.
We don't do that.
Yeah.
We don't do that.
Exactly.
Our food social ceremonial fishery is completely different, and it goes from August to October.
Yeah. We haven't been able to get tags for that.
Thank you both. Thank you, Mr. Batiste. I want to say a big thank you, of course, to Chief Ganesh and Chief Bernard for appearing before committee today and enlightening and educating us on this very important topic. That closes up our session for today. I want to say a big thank you to the committee members for your patience and indulgence, and as well to the clerk, the analysts, translators, and all the staff for putting up with us running over time again this evening. So again, we'll see everybody Wednesday.
Thank you for having us.
Thank you.
Bye-bye.